Providing ethnic diversity information. In 1994, a previously convicted child molester lived directly across the street from the Konka residence in a quiet New Jersey neighborhood. Given that, at that time, the police department was not allowed to divulge the addresses of registered sex offenders, no one in the neighborhood knew that the convicted felon lived there. In that same year, he murdered 7-year-old Megan Kanka. Given the horrific nature of the crime, on May 8, 1996, President Clinton signed Megan's Law, which recognized the public's right to know the addresses of persons who have been convicted of kidnapping children, committing sexual crimes against children, or committing sexually violent crimes. Since May 8, 1996, after releasing from prison, sex offenders are required to register with state authorities and provide the address of their residence. Law enforcement agencies commonly release the information when it is considered necessary to protect the public. Likewise, if a real estate licensee knows, as a result of information that law enforcement agencies have made public, that a sex offender resides within a client's area of interest, the licensee may be required to provide this to the client or face legal action. For this reason, licensees should consult with their office administrators to ensure adequate compliance with local law. No legal or ethical duty to provide ethnic diversity information. Consider the following case history. Joel and Zandra Hanna and their 3 school-age sons decided to move from Virginia to Cincinnati, Ohio, for both lifestyle and employment reasons. Before moving, Zandra asked their real estate agent, Ms. Carroll, with Sibcy Klein Realtors in Cincinnati, whether the areas that the agent had suggested were ethnically diverse. Both of the Hannas said that Carroll had told them that she could not give them the information they were requesting. Zandra had asked Carroll where she could get information concerning the ethnic diversity of schools and communities, and asked if organizations existed that she could contact regarding the ethnic diversity of neighborhoods. Zandra said that Carroll responded that no such agencies or organizations existed, and that Zandra could acquire the information by driving through neighborhoods. Zandra never received the requested information from Carroll. The Hannas eventually moved into a home sold to them by Carroll. However, after a year, they moved because of dissatisfaction with the ethnic diversity of the neighborhood. Given this outcome, the Hannas brought suit against the real estate agency. In 2001, the case of Hanna v. Sibcy Klein Realtors was tried in Ohio. The case required the court to determine whether a real estate agent or broker has a fiduciary duty to inform a client whether a neighborhood or community is ethnically diverse, or direct the client to resources that provide ethnic diversity information. The court concluded that, while a real estate agent or broker may choose to provide ethnically diverse information to a client, or may direct a client to resources about the ethnic diversity of a particular neighborhood or community, the agent or broker does so at his or her own risk, and that the broker and agent has no fiduciary duty to do so. Benefits of codes of ethics. One very effective method that real estate organizations can use to promote ethical behavior within their organizations is to adopt an official code of ethics or professional code of conduct. Codes of conduct are also sometimes referred to as ethical codes or codes of honor. Codes of conduct serve as guiding principles that are designed to counsel, assist, govern, and rectify unethical performance, and can be highly effective in ensuring the ethical conduct of the members of these organizations. Some organizations also include penalties for non-performance, including lists of specific violations, in order to further bolster the effectiveness of these codes. In general, a code of ethics provides the following 5 benefits for organizations. 1. Establishes a benchmark self-evaluation. 2. Communicates professional responsibilities. 3. Defines acceptable behaviors. 4. Promotes high standards of practice. 5. Provides occupational identity. The National Association of Realtors promotes ethical professionalism via a comprehensive code of ethics and standards of practice that has been instituted within their organization. Their work exemplifies effective use of this practice. When a licensee obtains membership in a board of realtors, he or she agrees to follow the rules set forth by this code. Watch that age limit in ads. Have you checked your MLS listings lately for fair housing problems? Do you have statements in your listings that say something like 55 and over to own or 18 and over to occupy? You say, what's wrong with these if they are true? Here's what's wrong. Standard of practice. 10-1 states, realtors shall not print, display, or circulate any statement or advertisement with respect to the selling or renting of a property that indicates a preference, limitations, or discrimination based on race, color, religion, sex, handicap, familial status, or national origin. That sentence is very close to statements in both federal and Arizona fair housing rules regarding advertising, and in case you didn't know or you forgot, MLS listings are a form of advertising. 55 and over to own. The exemption in the law which allows qualified communities to discriminate against families with children allows them to prohibit only occupancy, not ownership. Read on for more information about the exemptions. 18 and over to occupy. In order to legally discriminate against families with children in Arizona, a community must have either 100% occupancy over 62 years of age or must have at least one person over 55 in 80% of the homes, and must hold themselves out as a 55 or over community in their CC&Rs and public statements. Meaning of senior adult. Even if the community meets those requirements, the phrase 18 and over to occupy indicates that the community is not holding itself out as a senior adult community in its public statements. And if the community allows occupancy between 18 and 55 years of age, which they can do for 20% of the occupants, they must still hold themselves out as being housing for older persons, which is 55 and over, not 18, nor 35, nor 40. Many senior adult communities require 100% 55 and over occupancy, which helps clear up any confusion. But, for those who don't, such representations in your listing could jeopardize their exemption, if they have one, or could lead to a violation of the law for you and the community. Lessons. There are communities in Arizona that discriminate against families with children on a regular basis, yet do not meet these requirements. Realtors put themselves in serious jeopardy by allowing, and sometimes assisting, these communities to illegally discriminate. And realtors should ask owners questions about whether their community qualifies for the exemption before they tell others otherwise. Don't ever get caught in attempting to prevent someone under 55 to purchase a home in a qualified senior adult community. Make sure they know about the legal prohibitions for occupancy, but don't prevent them from seeing or purchasing such property if they do so knowingly. Know what the realtor, code of ethics, and the law say about fair housing ads, and learn about the properties you list before you write things that could get you in trouble. See additional articles on the familial status exemption to the fair housing laws so you'll be following the law, giving yourself more opportunities to sell, and not limiting families with children from buying the home of their choice.